Ladies and gentlemen, hello. My name is Nigel Smith and I am your moderator for this third day of webinars from the Council of Europe entitled Data Protection Views from Strasbourg in Visio. We have a very strong lineup of speakers. After their presentations, we will have a Q&A session. So my team, or the team, is standing by to take your questions. Please use the Q&A tool within BlueJeans. Sandra, AZRIA is our first speaker to address the theme of how we should address the risks posed by facial recognition. Sandra, bonjour.
Bonjour, Nigel.
Bonjour. You have 10 minutes, please.
Okay, thank you. First, I would have loved to see all your faces, and I really hope that you've been through this difficult period safely and that you and your loved one have been preserved. So I'm here to make a quick recall about the guidelines about facial recognition. I only have a few minutes, so I will try to be really quick. The first category of public of these guidelines is for legislators and decision makers. So we have a few principles. Of course, the first one.
Sandra, we're not getting any audio.
Oh, okay.
Yeah, that's much better.
Okay, that's better. Okay. Sorry. So since the beginning, you didn't hear anything?
No, we heard your introduction.
Okay, okay. So I hope this is okay now. My first point is about the legal basis and the fact that in some cases, the use of facial recognition should be strictly prohibited. In my first draft report, I underline the example of affect recognition, which is a subcategory of facial recognition, and this is not based on any sound scientific study. So, of course, which poses risk in terms of access to insurance or employment or education. The second point about the legal basis is the national laws framework. It is really important that national laws provide a sufficiently precise and protective legal framework, particularly with regards to special categories of data within the meaning of Article 6 of Convention 108. In these cases, the safeguard could be, and I gave, of course, a lot of examples in this guideline, but this could be the minimum reliability percentage of the algorithm, the retention duration of the photo used for identification, the traceability of the process secured maybe by a blockchain, for example. Second point is the quality of the consents. Of course, this point is crucial in the use of facial recognition, and particular attention must be paid to the quality of this explicit consent. And in order for this consent to be appropriate, these guidelines offer the possibility that to ensure that the consent is freely given, that data subjects should always have an alternative solution. By example, using a password or an identification badge. And to ensure that this alternative is a real one, the process should not be too long or too complicated compared to the facial recognition technology. Otherwise, the choice will not be a genuine one. Third point about these guidelines for decision maker is the necessary involvement of control authorities. Several countries now wish to implement experimental facial recognition systems. And in this context, it seems really important to systematically involve the national control authorities, to consult them on any draft text, to give them access to the impact assessment carried out, to all audits or reports, and of course, to let them be able to propose useful corrective measures. Another principle will be the labeling or certification. This will be a real added value for me if it were implemented, designer should be able to communicate about the data they use, the temporality of his data, the diversity of his data, the known biases and how to avoid them, etc., etc. And all these criteria could be subject to labeling and certification in order to demonstrate to master facial recognition technology and the responsibility and ethics in the broadest sense. The last point for decision maker will be to try to raise awareness of those concerns beyond labeling or certification. All this information should be accessible to the data subject. In this context, it's necessary to train citizens and in a simple and educational way. By example, understand what it means to give out one's data, to understand how facial recognition works, to alert to potential danger in case of misuse. The second part of this guideline is about the developers and service providers. So we have 4 principles underlined. The first one is about data and algorithm quality, and of course, representativeness of the data used. The Article 5 of Convention 108 provides for a data accuracy requirement, and this point, of course, is central since it has been proven on many occasions that errors are frequent and have serious consequences. So the developers have to avoid mislabeling by sufficiently testing their system and identifying and eliminating significant disparity in accuracies, notably with regards to demographic variations in skin colors, age, and gender, and of course avoid an unintended discrimination. About the data life duration, we know that facial recognition tool requires periodical renewal of the data in order to train and to improve the algorithm used. At this point, it seems difficult to define a fixed renewal period, but we know that each algorithm has a percentage of recognition reliability during its development. And so it seems important to date and record this percentage in order to monitor its evolution. And of course, it will give another positive point about the reliability of the tool used. This company and these developers have also a role to play in awareness and traceability. So they should help organizations to apply transparency and respect for privacy. And this could be done by making recommendations and providing advice by, I gave also a few examples in these guidelines, by setting reasonable limits in the wording of the contract, on giving information about the reliability level of the algorithm, the record of successive version of this algorithm, etc., etc. Of course, another important and crucial point is privacy by design. This principle applies to all tools processing personal data, but concerning facial recognition, this should not be carried out only by technical people on a technical level. Other professionals should be involved in this implementation, including committees of experts from different areas, such as social sciences, law, ethics, etc. And they may provide the best framework to engage in debate. The last part of these guidelines is about the user organization, and they have to always keep in mind that there is a limitation on use. There is the principle of proportionality. So any entity using facial recognition technology should consider if the verification or identification use is needed. Of course, we should always pick the less intrusive technology. And second point is about data security. I have no idea how much time I have, so I'm trying to do this very quickly. Is this okay?
You've still got a couple of minutes.
Okay, great. So, thank you, Nigel. Data security, of course, any failure in data security have particularly serious consequences for data subject regarding facial recognition, because of course you can change a password and you cannot change your face. So very strong security measures, both at technical and organizational level, should be implemented. And this measure should evolve and over time and in response to changing threats or identified vulnerabilities, and also be proportionate to the sensitivity of data and the context in which facial recognition technology is used. Okay. The transparency is another principle, and we have to apply really strictly the Article 8 of the Convention 108 regarding the information given to individuals, the context on the use and the reasonable expectation. Of course, the impact analysis and risk assessment are another big principle in these guidelines. Obviously, where a public authority has not yet acquired or developed a facial recognition system, the assessment should be carried out prior the acquisition and should be made public. The accountability will be another principle to ensure that everything complies with the legal framework. This includes implementing training programs and audit procedures, and this principle should be contractually extended to third-party service providers. But my last point in these guidelines is a really important one, is the ethical framework. To follow all this logic, giving an ethical framework is a crucial issue. This could take the form of an external ethics advisory board that could carry out audit or publish the result of the research. And of course, in the guidance, which part the last part about the right of data subject to ensure that every right of a data subject apply in this use. Thanks. I hope I'm okay.
Yes, you are. An excellent start to our conversation there from Sandra. Thank you for presenting the draft guidelines produced by the Committee of Convention 108. Let me now go to Tamas MOLNAR. Tamas, from the European Union's Agency for Fundamental Rights, are you with us?
Yes, I am. Hello, I can hear you, I can see you. I hope that it's the same for you.
We're not seeing you, but I'm hoping that will change soon. Tamas, you have 10 minutes, please.
All right, thanks a lot. Thanks very much for the introduction. I also prepared some slides. I hope that the IT colleagues supporting us can now put them on the screen. Yes, I just can't share it. We discussed beforehand. Yes.
Your
wonderful.
Slides are there.
Yeah. If you can't see me, I hope that now my camera is on. Everything should be working. I don't know why you can't see me, only hear me. But without further ado and not to lose more time, I think I jump into the presentation, if you don't mind. So,
no
all right. In this 10 minutes, which is in itself quite challenging, I'll try to introduce our recent focus paper on facial recognition technology in the context of law enforcement and how it affects different fundamental rights. Before we just start with the content, first of all, I'm very grateful to be here, and thanks the organizers for having invited Fra and myself to talk about our research findings. So please, next slide, just to give a bit of a context of this paper, and I can see that some technical hiccups occurred when it comes to the titles, but never mind. This research draws on previous and ongoing FRA research. 2 years ago, we published a report on biometrics in large-scale EYT systems and fundamental rights, and currently we have a big research project on artificial intelligence, big data, and fundamental rights. So this FRT-related research fits into that. I have to make some delineations. The report only focuses on live facial recognition technology. used by law enforcement. So it's only law enforcement, only public sector. We don't cover private use of this technology. And the main focus, again, is on live FRT. And next to text research, the analysis is based on interviews with experts and practitioners from selected member states, notably the UK, Germany, and France. And this paper has also a prominent legal side, given that it discusses selected fundamental rights implications, providing a preliminary legal analysis of a number of fundamental rights and the FRT-driven implications, especially those ones which are most affected by this technology. Please, next slide. Here, when discussing fundamental rights and FRT, it's important to distinguish between different forms, but I think I will just drop it. So only telegraphically, we describe the three main forms of this technology. First is verification, the so-called one-to-one comparison, which is used in our cell phones or at ABC gates at airports already in some countries. The second is identification, the one-to-many comparison, when one image is compared to several others in the database in a so-called watch list. And this is where live facial recognition technology comes in, and this is the context where we focused the most. And the third possible way is categorization, when this technology is used to profile people, to identify the gender, ethnicity, and age, which is highly problematic. It raises delicate ethical and legal issues as well. Please, next slide, or even you can turn. I think I will skip the accuracy issues and I will just focus on the core legal stuff, which starts at the next slide. So when speaking of fundamental rights considerations and about the more horizontal issues, it must be stated that this technology entails both risks and opportunities. Speaking of risks, these are the errors, the error rates, and also the risks stem from the weak position of the individual. Opportunities mainly, concern like public security driven gains, such as fighting terrorism and other forms of serious crime. But this technology can also help trace missing people and victims of crime, including children. Public perceptions are key when we dig deeper. Although there are no EU-wide thorough surveys on that matter, but a certain share of the population feels uncomfortable with the use of live FRT. Recently, our agency published its first fundamental rights survey, which covered more than 35,000 people, and one of the questions was quite illustrative in this regard. The findings show that less than 2 in 10 people in the whole EU would be willing to share their facial image for identity purposes to use services offered by public administrations, and less than 1 in 10 people would be willing to share their facial image for the same purpose when the service is offered by private companies. The 2 in 10, 1 in 10, in both contexts, it shows the major concerns. And it leads also us to human dignity as a concept where analysis needs to start. Human dignity is the foundation of fundamental rights. This is the mother right of all others. And it comes up really strongly in the context of live facial recognition technology, which is used mainly without the consent of the people. And human dignity can come up in different contexts. I mean, people might want to avoid areas which are under surveillance, and if it's done in a mass way, police have to stop a large amount of people, and false positives do occur. And I mean, all this, how to say, unlawful stops or unnecessary stops, and if the police behave not the most appropriate manner, of course, infringes upon human dignity. And going into the details, there are different requirements for justified interferences with a given fundamental right. The EU Charter and the ECTHR case law give indications on those, how to say, criteria. There are two tests which correspond. And in the EU context, the essence of a right is of utmost importance, which cannot be emptied, cannot be, how to say, defeated by a given interference. If this is the case with the technology, it's a no-go, it should stop. And the necessity and proportionality test can be conducted only after making sure that a given measure like this one does not defeat the essence of a right. Plus, the extent to which fundamental rights can be limited depends on the purpose and the use, the purpose of the use and the context of the use. So law enforcement and fighting against terrorism, serious crime, usually set the bar a bit higher. Then, given that technology will never be perfect, we need to ask ourselves what level of false positives can be accepted given a certain success rate. So how to balance the accuracy, which has also implications when carrying out the legal test, the fundamental rights compliance test. Please, next slide. So this is just a list of selected fundamental rights which are most affected, and we discussed in the report. First and foremost, the technology interferes with the right to respect for private life and protection of personal data. Here, all the data protection standards, safeguards, and principles come into play, which stem from EU law, the GDPR, and other instruments, as well as Council of Europe instruments. Second, the technology has also shown to potentially discriminate based on gender, ethnicity, and age. So based on tests, we see that it worked well for white male, but less well for black women, for instance. And there are also issues with children and older persons. In case of children, the accuracy rate is quite low for those who are younger than 13 years of age, and the same applies to the elderly if the facial image was taken many years before the check. So rights of the child and older persons also affected. Then, speaking of the freedom of assembly and association, the freedom of expression, in this context, the key issue is the chilling effect. The chilling effect, because some people really don't want to be subjected to the technology, so they don't go to demonstrations. And the number of procedural rights can be affected, such as the right to good administration or the right to an effective remedy and a fair trial. Since it's crucial that people know that they are subjected to FRT, because only then they will be able to challenge any unfair decision. But if they don't know, and in many cases this is an issue, then how to proceed further? Plus, under the right to good administration, how to ensure access to the files if huge numbers of people are under the surveillance. So practically speaking, the access to files can be an issue. And also in the context of effective remedy, people might challenge FRT-related measures for different reasons, why they are in a watch list, for instance, why they have been under surveillance in absence of their consent, and also if they are stopped unlawfully, as in case of a false positive, they might seek compensation if they miss the train or an airplane off, or if they have been prevented from entering a country and therefore they missed a business meeting. So wrapping it up, please, next slide, which is the last slide, a few recommendations in the report. A clear and sufficiently detailed legal framework is needed to regulate face recognition technologies. This is a must. And we have to acknowledge that different fundamental rights risks come into play. These depend on the application, whether it's verification, identification, and the context of the use, for instance, during demonstrations. It's also important to assess the purpose of the the technology, especially in case of live facial recognition, then fundamental rights impact assessment is an essential tool which needs to be carried out before deploying. Then when procuring this technology, public authorities should build fundamental rights considerations such as data protection, non-discrimination into the technical specifications and contracts. And last but not least, as the technology is developing very fast, close monitoring by independent supervisory bodies is central, and oversight authorities need to have sufficient powers, resources, and expertise in future. And I stop here. Thanks very much for your attention, and sorry for being a bit longer. Yeah, you can go to the last slide.
Thank you, Tamas, for sharing with us the views of the European Union Fundamental Rights Agency concerning the risks and safeguards associated with facial recognition technology. Let me now go to Carly Kind, who is the director of the Ada Lovelace Institute in the UK. Carly, are you with us?
I am. Can you hear me okay?
Yes, we can hear you, but we can't see you. So, excellent.
Okay.
Carly, you have 10 minutes, please.
Great. Thank you so much. I am just going to share my screen. Give me 1 second. I hope you can see my screen. Nigel, please let me know if you can't.
Yes, yes, we can.
You can. Great. Okay. Hi, everyone. My name's Carly Kind, and I'm the director of the Ada Lovelace Institute. We're a think tank and research institute based in London, and we have a remit to ensure that data and AI work for people and society. That means that we work from the starting point that human rights are important, but so is things like public deliberation. We think a lot about ethics and how to come at these issues both from a rights angle, but also with considerations of societal impact and societal values. We've been working on facial recognition for about a year now, and I want to walk you through in this presentation a public attitudes survey that we did last year, and with a short update on some other things that we're working on as well. So in the UK, the question of facial recognition has been a live one, in particular since last summer. We had a series of events, including the UK Biometrics Commissioner, who's an independent expert with the remit to oversee the application of biometrics-related policy and law, concluding that the UK's framework for biometric data wasn't sufficient to govern the new biometric technologies that were emerging, in particular facial recognition. There was also the emergence of live facial recognition used by the Met Police in London beginning last summer, with trials in various parts of London. And we also saw the use of live facial recognition technology in the context of private premises, commercial premises around the King's Cross area of London. And you can see there on the slide a tweet from the Mayor of London raising concerns about that. So there was certainly a increased interest in the issue of facial recognition in the UK last year. And there was also a court case ongoing at the same time. In July last year, we instituted a survey of public attitudes towards facial recognition in the UK. We surveyed around 4,000 people. And we were particularly interested in public attitudes, the use of facial recognition in the context of specific use cases. I think Tamas mentioned this a number of times in his presentation, the need to look at the use of the technology in its use case is quite important for thinking through the rights implications. We use facial recognition as an umbrella term, but I'll come back to that at the end of my presentation. We used case studies, and we also didn't elaborate to the people we surveyed what safeguards are already in existence, because that is a pretty contested thing, I would say. So we found that awareness of facial recognition technology is very high, but people don't know a lot about it. So they've heard of it, but it's not something that they know a lot about. We found importantly that consent was a very important safeguard for lots of people. So we found around half of people think that they should be able to opt out of or consent to facial recognition technology. This is an interesting finding because in the UK, the major use case at the moment is police use of facial recognition technology, which isn't subject to consent as a legal basis, which falls under other legal bases. So it's interesting that there's that feeling of the need for the public to have agency or control over the use of this technology. We found that people do fear the normalization of surveillance, but on the whole in the UK, they support facial recognition technology where there is public benefit and where there are safeguards in place. So we looked at 6 different use cases, and we can group 3 of those into kind of cases with public benefit, so criminal investigations and airports being the major applications there, and then potentially cases with less clear public benefit. You could equally split this along public and private or commercial uses as well. So you can see that there's quite a distinction between police use of facial recognition on the one hand and the public support thereof, and on the other end of the spectrum, the use of facial recognition in the context of employment or in schools. We found that there wasn't unconditional support for police use, however. So people did express concerns around the privacy violations that the use of facial recognition occasions, and concerns around ethics and ethical use. But and importantly, we found that there should be a restriction of how the police should use facial recognition by the government. That is, that there should be some type of regulation curtailing police use of facial recognition. And we did find that there was more support for police use of facial recognition in the context of criminal investigations, where as opposed to at football matches, for example. So this distinction between live facial recognition versus retrospective facial recognition run against a CCTV footage, for example. We found very low levels of public trust in the private sector use of facial recognition technology. We found the large majority of people were uncomfortable with the prospect that facial recognition could be used in shops or in recruitment processes, for example. And of those who said that they were uncomfortable, the majority said they were uncomfortable because they didn't trust the actor to use it ethically. We also found that people felt the government should act, in particular to limit police use of facial recognition technology, to limit schools' use of facial recognition technology. And we found that more people agreed than disagreed with the statement that the government should outlaw the use of facial recognition technology in schools, although equally you could say that there is not insignificant support for school use of facial recognition technology. So I think there is some interesting contrast in these findings. We also asked people about their support for a moratorium on facial recognition technology, and we found that around half of people think that the private sector should stop selling facial recognition to technology so that the public can be consulted about its use, and the large majority of people agreed with that statement with respect to schools as well. So in terms of what the Ada Lovelace Institute is doing now, following up from that survey, we have been, we've commissioned an independent legal review of the legal framework in the UK governing biometrics data. We've convened something called the Citizens Biometrics Council, and we're advocating for a moratorium on further deployments of facial recognition technology. We've commissioned Matthew Ryder QC, who's a well-known human rights lawyer in the UK, to survey the current governance framework around biometric data and biometric technologies, to take evidence, and to advise on legal and policy reforms. We've convened a Citizens Council of 60 members of the public across Bristol and Manchester, and they are engaged in a deliberative exercise, which is like a long-form public engagement or a long-form focus group where members of the public take evidence from experts over 6 weekends and develop recommendations based on consensus of the group. That initiative was halfway through when COVID hit, and we will be finishing the rest of it in online fora later in the summer. And as I said, we've been advocating for a moratorium on facial recognition technology. We've been calling on companies to pause their sale of facial recognition until some of these difficult issues are resolved. And of course, we've seen recent moves on this front with both Amazon and IBM coming forward to announce that they will impose their own moratoria on their further sales of facial recognition, or in IBM's case, to stop selling facial recognition for the moment. At the moment, we're focused on broadening out the conversation around facial recognition. There's been quite a narrow focus on accuracy problems with facial recognition, in particular around bias, and Tamas touched on some of these. Whereas, of course, those are very important questions, and does the tech work should be the first question we ask about all technology. We believe that there are a range of other questions that facial recognition raises that need to be addressed with some urgency. And we've been looking throughout the COVID crisis at the links between conversations around biometrics and conversations around COVID tech, in particular contact tracing apps, but also the emerging conversation around health status apps and immunity certification, and the likelihood that biometrics will be integrated into those apps. And we've published a number of pieces around that as well, which you can find at our website. To be finished, I've had the bell, so I'll wrap up. Some high-level reflections on the draft guidelines. Firstly, I think that the focus on accuracy of the technology does obscure the more fundamental societal questions that this tech raises. And I think it's not enough to ensure that the tech works well. We need to be asking about whether there are red lines in places that we shouldn't be using facial recognition at all. In that context, I think it's really important that we have a very detailed and nuanced conversation where we distinguish between different things. So we distinguish between different functions of facial recognition. So all facial recognition tech is not alike. There are some which just detects face, some which matches faces to other faces, or they're at the other end of the spectrum, which the guidelines do recognize the idea of affect recognition or face classification, which is much more problematic. I think we really need to distinguish between use. So the passive or remote use that we maybe used on crowds, for example, to recognize anonymous people, versus an active use where you might integrate it into a biometric ID or something that you use on your phone. And then definitely in terms of context. So are there places where we don't think that this tech should be used? Schools, workplaces, etc. And I think there's a need to look beyond facial recognition technology, and I would underscore this for the purpose of the guidelines, that this is only the first of biometric recognition technology that is going mainstream, and anything that focuses solely on facial recognition may become outdated very quickly. Thanks very much for having me.
Thank you, Carly. We all look forward to reading the final report from Matthew Ryder QC when it is available. Let me go to our last speaker and also encourage you to send in your questions using the Blue Jeans Q&A tool. We've already had some. I'm sure there'll be more. Vincent, I can see you on the screen. You have 10 minutes, please.
Good afternoon, everyone. Let me start by thanking the Council of Europe for the invitation and the opportunity to speak to you today. Of course, this is on behalf of the ICRC and our Data Protection Office. Also, I'd like to have a small disclaimer. I'm a mathematician by training. I'm not a lawyer, so I'll do my best to use the appropriate language, but please excuse me if at a couple of occasions I might fail in that. So a month ago, I'm sure most of you have seen that, but we released the second edition of our handbook on data protection in humanitarian actions. I have to say, we are proud of the result of this handbook, which is the result of a long series of very inclusive workshops that involve the Council of Europe, the French-speaking Association of Personal Data Protection Authorities, several statewide data protection authorities from Switzerland, Senegal, Belgium, France, and Spain, a lot of other international organizations, civil society, and as well academia, who helped us a lot, in particular with the more technical, hardcore computer science side. In the second edition, we actually added 5 totally new chapters. They cover artificial intelligence, blockchain, digital identity, social media, and connectivity as aid. Now, it's interesting to see that, or to reflect on the fact that digital identity may have been for us the hardest chapter to really address. And that might be because it is less of a well-defined technology than, to say, artificial intelligence and blockchain. Now, it's also interesting to realize that we acknowledged during the workshops that both AI and blockchain are actually very new technologies, and they're evolving a lot and very fast. So while we came up, as I said, to a consensus pretty easily, we have all to be very vigilant on how this technology evolves, because it happens pretty much daily. During one of the workshops, and it was probably a coffee break, one of the conversations we were having suddenly came to the fact that perhaps the biggest nightmare when it comes to data protection and technology would be a project that intends to build digital identity using biometrics with everything stored on the blockchain. Now, with regards to biometric, of course, and facial recognition, sorry, we know that this is biometric data. In the case of the ICRC, we published our biometrics policy back in August 2019. And this policy actually recognized that the ICRC has a legitimate interest, as well as in some of our activities, we even have public interest to use some kinds of biometric-based technology. One of the reasons is that part of our mandate is to work toward clarifying the fate of the missing in conflicts and other situations of violence. Now, if you want a more detailed reason on that, I encourage you to look at the policy, which is actually published on the internet. Now, clarifying fate of the missing, that has been work we've been doing for decades, and this is a lot about collecting personal information. And we did that for almost a century now. We had prisoners of war that were registered consistently and thoroughly by our tracing agency. And today, we actually still receive inquiry for World War II cases where people are looking for the fate of some of their family members. We also have hundreds of staff in the field around the world working on collecting new cases, on collecting new data, and of course trying to resolve these cases. We more recently started to offer some digital and online services to help people looking for their loved ones. We have, for example, a website called Trace the Face for European Migrants, where you would see pictures. Now, of course, there we don't publish pictures of people we're looking for, and these databases are anyway not publicly available. But on that website, you will see some people that came to us and that agreed to publish their own pictures so that perhaps the people they look for would see it and contact them back. Now, in the specific field process that happens when such a tracing case is open involves specially trained staff that works with the family that are going through a lot of different controls to make sure this is a sort of a quote-unquote lawful case. And they actually start collecting information from day one. And they start from missing, either through some other databases or lists we have, but also sometimes they collect pictures of people, and they also include these pictures into the case. And then we have to compare pictures, again, of the list that we own. Now, as you can imagine, this is extremely long, hard, and also for the family sometimes pretty difficult because you keep seeing pictures that may look like your sister, your brother, or your husband or wife, but sometimes it's not the right person. And going through all these pictures is really complicated. And we heard before dignity, and we think that sometimes that might not be really dignifying for the people. So we decided a while back to evaluate how facial recognition could help us. Now, we did it by putting a lot of safeguards. And to be honest, as a technologist, I would say that how come that over these many years, because we started a few years ago, how come we haven't yet come up with solving cases with facial recognition? How come we don't have massive production systems using it? That's because, again, it's more complicated than we think. So one of the things we decided was, of course, to only use data in our premises. So we don't use any of the cloud technology that Holly was mentioning, whether from Amazon, IBM, or Microsoft. We have to use our on-premise infrastructures because that's the only way we can guarantee our special legal status and privilege and immunities. Now, of course, not all the technology is available in that manner. We also only use images that have been somehow, where despite the fact we have the right legal base to process, we can't just process any image that is in our possession, right? We can't just upload images and look through our database like that. So we have to be careful and source back what the image was, because of course at the time we never asked consent for facial recognition, because we didn't have that before. So we have again very dedicated staff which is authorized to get the right images, process them into a contained environment, and have the first look at the result. Now, of course, results, and that's one of the also element mentioned earlier, results were not that good. As you can imagine, and because we know the bias, especially racial and sex, gender bias that are embedded into face recognition, the places where we work are quite often precisely that kind of population. So the darker your face is, if you're a woman or if you're a kid, it's even worse, right? So we were hit, and we are still hit quite badly with bias of these algorithms and technologies. Now, every computer science, machine learning researcher will tell you, if you have such a problem, it's simple, just get the right data, retrain your algorithms, and you will get what you want. Right, but then how do you get access to this training data set? Yeah, some scientists even told us, but then you are in the field, why don't you just take pictures of people around and use that to train? Now, of course, we can't do that, right? That wouldn't be the right things to do. So training set, data set availability really is a problem for us. So at the moment, we're still working on these algorithms. We are getting better at having them, but we have a few other challenges, and I'll get back to that a bit later. Now, as it can be seen in our handbook, I think that our position of the ICRC with regards to artificial intelligence, machine learning, and facial recognition are quite aligned with what we can find in the Council of Europe draft guidelines. But I'd like to emphasize on a few elements that I think could be added in some shape or forms. The risk, amongst the risk of these algorithms, and we heard again a lot of different elements from Tamas and Kali earlier, we have some very more technical risks, right? So machine learning systems have to protect the data subject. So if my picture is being evaluated, I need to be protected. But of course, as we said, data sets used to train the systems are also coming from real people. So these are also somehow data subjects. So how do you protect these people? Now you might say, why would we protect these people? Well, that's because we've seen that some attacks are possible to have, for example, membership inference. So it's pretty easy to verify if you have been part of a data set which was used to train a systems. So in certain cases, that can tell a lot about you. Some other attacks are also, of course, poisoning systems, right? So if you want to force an algorithms to give certain type of results that can be used for your for yourself, there are ways to do that, and it's pretty hard to find out. Now, I think to conclude here, I would say that I think, and I think it's shared in the ICRC, but existing modern data protection frameworks are quite well adapted to all these challenges. But I think it requires a slightly different mindset in perhaps not your community, but more the rest of the people, is to say that data protection really is not about only the compliance part, and that we strongly believe that protecting data is about protecting people. So continuing the effort to design and develop the right data protection frameworks and guidelines is absolutely key to resolving and protecting people. Thank you very much.
Thank you, Vincent. Now we're going to move to the Q&A part of our webinar. Let me bring in Tamas Kaldani, who is the Vice Chair of the Committee of the Convention 108 from Georgia. Tamas, are you with us?
Yes, I'm here. Can you hear me?
Yes. What is your question, please?
First, let me thank and express my appreciation to the Council of Europe and speakers for a very enlightening session. The topic that we're discussing today has become very challenging during pandemic, and we all witnessed the extensive and intrusive application of untested systems. So I believe that the work of the TPD in this regard has become even more meaningful. So my question specifically to Sandra, AZRIA, is what new normal has changed for the work of TPD? Do we need to analyze the use of FRTs by parties and address more specifically the legal, technical, or ethical aspects of the use of such technologies during emergencies. Thank you once again.
Thank you, Tamas. Sandra, did you hear the question?
Yes, thank you, Nigel. And thank you for this question, which is really, of course, important in this particular time. And yes, I think this pandemic gave us exactly an example of which problem we can meet. And the difficulty is always, and I agree with Carly about that, the use of facial technology, recognition, of any technology giving us information about people is always the contents, the use. And of course, the problem is that in some case, like during this pandemic, people would agree about the, yes, we have to give all of data of the people we meet and et cetera, et cetera. So I think, yes, I agree. We need to be much more specific, much more, allow me to say aggressive about this subject and try to think about all the misuse possible and all the difficulty we can meet. So yes, my point of view is, of course, work very much more closely to imagine all the ethical problem we could meet.
Thank you, Sandra. I've got a question from Eduardo Bertoni from Buenos Aires. This is for you, Vincent. As a DPA in Argentina, we understand that facial recognition technology includes personal data collection. In most cases, the data is stored in databases. If that is the case, do you have good examples on how to grant the data subjects their right to access? Same for the right to information. How would you respond to that, please?
Well, it's a complicated question, and it depends if we look at just best practices or how we enforce that. Now, in our case, as I said, so when we look for missing people, we have a different legal base. So basically, if a data subject there, which hopefully one day we can find, would say, I want you to delete the data, we have different grounds for keeping archives and so forth. Now, in other areas where we use biometrics, for example, to register sometimes beneficiaries in the field, we actually don't store the biometric. So precisely for these kind of reasons and for other type of risks, we don't enforce a one-to-many type of functionality. We have like device embedded biometric, like a card or on your smart, whatever, usually more of a card. And this is only used for authentication. So the problem of solving, as you said, of letting people be able to have the right data agency is super hard. And in particular, it's super hard when we get to retraining data. So imagine that you have 1,000 people that give you consent to retrain your data set. And all of a sudden, one of them says, I don't want to be part of your data set anymore. You would have to retrain. So at the moment, to be honest, in production and real life, I would say, we have systems where we don't really have that problem. Hope that answered the question.
Indeed. Let me go now to Tamas Molnar. I hope you're still with us. We've got a question here from Tommaso Falcetta, Tamas. The question is, are there any contexts where facial recognition technology should not be deployed? For example, monitoring peaceful demonstrations. What criteria can be used to identify these red lines? You spoke of red lines in your presentation, I think. So how would you respond to Tommaso's question?
Thanks very much, Nigel, for forwarding this question, and thanks, Tommaso, for asking this question. I mean, in our report, we generally touched upon this issue, but at a certain level of abstraction, since this is not our task to give concrete guidance, but we just set the parameters. So the report concludes that those forms of facial recognition technology, which have a very high degree of intrusion into fundamental rights, comprising this inviolable essential core of one or more fundamental rights, are unlawful. So this is how we framed the essence of the rights test needs to be carried out. And if a given measure in a given context empties or defeats the very core of a given fundamental right or more of those human rights, then it's a no-go, it's unlawful. But we have not given, how to say, examples, since we see this is the text, this is the test, sorry. And if there's no legislation, black letter law, which unfolds it or builds upon that, then it is up to the courts, national or European courts, to give guidance by their jurisprudence if such cases reach those jurisdictions. So yeah, I know it's not very specific, but at least this is the way we see the general framework of assessing which technology is allowed and which is not.
Thank you, Tamas. Let me go now to Carly. We've got a question that comes in from one of the people following us on Blue Jeans, but who doesn't leave his or her name. Clearview, you will be aware of how Clearview has come into the press recently. This question says, what can be done about Clearview's accumulation of billions of photos on the internet and social networks to feed its facial recognition system and then sell it on to the police and also to companies? What should we do? What needs to be done, please?
Yeah, it's a great question because it touches on Vincent's really important point that I think we should underscore, which is it's not only the data of the people images are being processed when facial recognition systems are used that is relevant to this conversation, but the data of people whose data is being used to train the systems. And in the case of Clearview AI, as the person who asked the question points out, they scraped image data off millions and millions of websites in contravention of websites' terms of service in order to train their algorithms. And it's a very complex question to ask how you give those people data agency, data rights. But certainly from an accountability perspective, we can at a minimum ask that public bodies, for example, are restricted from using facial recognition systems that are trained on data that's acquired unlawfully. And I do think that the guidelines touch on this in terms of accountability around training data, but it's a really important point. It's easy to get lost in it because it's quite technical, and I thought Vincent's explanation was very clear, but there is a line in the sand that you can draw there on systems which use training data that is required lawfully, and there are some minimum standards around representation and accuracy versus systems that are built off the back of unlawfully acquired data. And I think it's important that we all become versed in that distinction sooner rather than later, because the same problem applies with other AI systems as well, which we'll get on, at some point, whether it be kind of risk scoring in public service provision, for example, or algorithms trained to allot visas to applicants. These are the question of accountability around training data is a really important one.
Clearly, we could continue for another 10 or 15 minutes on this subject, given the number of questions we've got coming in. But for our last question, as we're into the last 2 or 3 minutes of our webinar, let me bring back in Sandra. Sandra, we've got a question here from Pierluigi Perry. He asks, what is your view about the necessity test of Article 8 of the European Convention on Human Rights and how it can be effectively used as a safeguard against very intrusive technologies like facial recognition or bulk interceptions? We saw that proportionality may be a very vague and changing concept. How would you reply to Pierluigi's question, please, Sandra?
Oh, I'm sorry, Nigel. I didn't hear the beginning of the question. Can you just tell me the first?
Sure. Pierluigi asks, what is your view about the necessity test of Article 8? Is that good?
Yes, that's good. Okay. I didn't hear about the necessity test. Oh, okay. That's a complicated one. Okay. The first thing, you cannot isolate all the legal requirements. You cannot say, okay, with accuracy, you've resolved all the problem with the test and you resolved all the problems. You need to have all the legal frameworks to ensure a proper use of facial recognition. Just a necessity test will not provide sufficient measure. It's all the work you are doing with all the legal requirements for me, which will be useful.
Thank you, Sandra. Let me now bring this webinar to a close. My great thanks to Tamas, to Carly, to Vincent and to Sandra for their excellent presentations. Also, let me say thank you to those of you who've sent in many questions. We haven't been able to ask them all, but there were so many. It's a very fascinating subject. And of course, thank you for following us online. Join us again in the next few minutes where we'll be discussing in our final webinar data protection issues related to political campaigns. So on behalf of all of the team here, Bumila, Sophie and all of the people here at the Council of Europe who've helped to make this webinar series possible, let me say thank you very much and goodbye.